Budget 2022 hits all the right notes. Deconstructing proposals for infrastructural development on a macro level establishes focus on multimodal connectivity. Key transformative elements in this arena for enhanced productivity include the Unified Logistics Interface Platform for intra-operator data exchange, surety bonds to substitute bank guarantees, settlement of running bills within a restricted time frame with increased recognition to dispute resolution, and new transparency criteria laid out for government procurements. Expansive policy measures in sectors of renewable energy, electric vehicles, healthcare, education are under rolling out, establishing comprehensive developmental goals. Tech remains center stage. Delivery to farmers, including through drone technology, likely to prove transformative from the standpoint of agrarian reforms. Digital banking by post offices within the snare of the core banking system, again a logical extension of tech-enabled integration. Energy sector addressing distribution losses with the benefit of tech-enabled reforms, again clearly the way forward. Announcement of the futuristic central bank digital currency, CBDC, scheduled to be introduced in 2023, will significantly alter the landscape of monetary dealings going forward. India's leadership position on information technology portends world-class technology accompanying the digital rupee, capable of propelling India into the status of a unique forerunner with the privilege of setting new benchmarks across the globe. On the direct tax front, 3 tax measures merit particular attention. First, cryptocurrency or virtual digital asset transfer tax. The rate of 30% coupled with the lack of allowability of deduction or expenditure, the lack of set-off of loss, and the bar on carry forward of loss all appear aimed at disincentivizing traders of VDAs. Tax deduction at source requirements, including on sums paid into a suspense account, become operative July 22. Second, the extension of tax incentives to offshore derivative instruments and ship leasing in units located in IFSCs, again of interest. It establishes India's commitments across the global landscape of international financial services centers. Third, cash credits. Dealing with the vexed onus as to source of sums recorded as loans or borrowings clearly has elements of policy with analogous consequences. On the tax policy front, at least 11 structured measures or clarifications warrant interest. First, the curbing of litigation with taxpayers through measures for management of appeals. Where identical questions of law arise, mechanisms for cases pending before the apex court will permit our judicial resources to be put to better use, thereby considerably alleviating litigation pendency. This measure is particularly emulate-worthy, in fact, across all genres of litigation in the country. It is also the right step forward in terms of direction of certainty of income, taxability, and bringing with it mutual advantages to both assessee and revenue alike. Next, promoting voluntary tax compliances through extending the time frame for the filing of modified tax returns within a restrictive framework, no doubt, of enhanced income and a requirement to pay up additional tax. This, in my view, is analogous to tax amnesty in some form, no doubt. Next, treatment of cess and surcharge, whether claimable as allowable expenditure, is now clarified, citing a 1972 apex ruling to conclude that the Bombay High Court and the Rajasthan High Court were per incuriam. This position stands retrospectively amended effective 05. Next, taxation on reorganization or restructuring, including filing of modified returns of a successor entity or for entities going forward through a corporate insolvency resolution process under IBC, Insolvency Bankruptcy Code, has been clarified. This was a clarification, in my view, overdue. Next, the matter of Section 14A disallowances, clarified through an explanation that proceeds on the footing that it shall apply where exempt income has not accrued or been received and expenditure incurred in relation to that income. A fair clarification, in my opinion, capable of ensuring due implementation of legislative intent. Next, on the allowability of Section 37 expenditure, subject to lawful activities, resonating the 2013 opinion of the Himachal Pradesh High Court in Confederation of Indian Pharmaceutical Industry and the recent October 2021 McLeod Pharma judgment of Mumbai ITAC, clearly the consistent views of courts and tribunals has also finally paved the way for introducing TDS on benefits or perquisites. Phasing out exemptions to expat employees and consultants in G2G projects effective 1st April 23 is a disruption of existing G2G arrangements, and whether warranted or not is no doubt a policy departure, but when measured against the impact of such phasing out, is a matter that, in my opinion, perhaps warrants reconsideration. Extension until March 23 to commence domestic manufacturing companies' activities to avail of the 15% corporate tax provided specified incentives and deductions are not availed, of course, was inevitable given that we live in Omicron times. Extending bonus stripping and dividend stripping provisions to units of InvITs, REITs and AIFs was again perfectly warranted. Withdrawal of concession rates on dividend income received by Indian companies from their foreign subsidiaries brings at par a position that was bound to get aligned at some point. On the SEZ 2.0 legislation, the drivers are clearly manifold, including the complaint made by the United States leading to the World Trade Organization panel report of 31st October 2019 on matters concerning export-related trade measures of India, particularly in the realm of trade concessions. This, of course, is an appeal by India and no doubt an outcome that must ultimately have direct bearing on policy initiatives going forward. To aid disinvestment policy, carry forward of losses in strategic disinvestments of public sector companies is a key measure that has been announced, no doubt relevant to the recent transfer of Air India over to the Tata Group. The Cabinet Committee on Economic Affairs recently approved the Tata Steel long product bid for Neelachal Ispat Nigam Limited. We also have in the pipeline Bharat Petroleum, Shipping Corporation, Bharat Earth Movers, Pawan Hans National Seeds and so on in the pipeline. And then of course the much awaited IPO of LIC to be followed by ECGC and a 49% stake sale on the cards by ONGC. Overall, amazing momentum in my opinion, capable of being fruitfully achieved in order that long-term objectives are constructively secured. The framework for inclusive growth permeates and has been well laid in Budget 2022.